Hey guys, it's Miss Sheehan, and this lecture is to start off our unit on civil rights. The major civil rights movement was happening concurrently at the same time with the Cold War, primarily during the late 1950s and early 1960s. So today what we're going to talk about is the thing that really kicked off the civil rights movement for African Americans, which was the Brown versus Board of Education Supreme Court decision. So I'm going to do a lecture on that and then kind of some of the consequences or fallout of that. And I would like you to take notes. Okay, share my screen. Okay, so let's start off with some definitions first. So there are two major types of race-based segregation in the United States. And kind of there still are. So the first is what's called de jure segregation, and jure in Latin means law. So you can think of like jury law, right? So de jure segregation was segregation mandated by law. So that was like when public facilities were legally declared to be segregated, right? So like a famous picture of the white bathrooms and then the bathrooms for colored people, right? That's de jure segregation, or people of certain ethnicities can't live in a certain neighborhood, right? Or they can't go to the same school, things like that. The other type of segregation that's maybe more common today is what's called de facto segregation. And that is segregation that is not legally mandated, but it happens anyway. So a lot of time this is like segregation of neighborhoods, right? White people tend to live in the suburbs, things like that. Segregation of facilities or opportunities or access that happen just by the fact of how our country works, right? Rather than it says, this is the law. So what we're mostly talking about when we talk about the civil rights movements during the 1960s is fighting against de jure segregation, right? And trying to end those laws that made a segregation possible, right? And then what the continuing fight since the 1960s has been working on ending de facto segregation, which is unfortunately still very prevalent. Okay, so our background to this goes all the way back to the end of Reconstruction with the introduction of Jim Crow laws, which you might remember were the laws primarily in the South, but they also existed in the North, that separated white and Black people in public and also in private, right? Black people couldn't sit in a certain train car. They couldn't drink from a certain water fountain, as you're seeing here. They couldn't go to the same schools. Often they couldn't have the same jobs, right? Things like that. So remember, this was an effort by people who had been disenfranchised by the end of slavery, so usually whites and white slave owners, to try and bring back the system of slavery without reinstating slavery. Because slavery was illegal, but they still wanted or felt like they needed to oppress people of color. And these Jim Crow laws, which were the way that they did that. So, right, these are between 1876, so the end of Reconstruction, and 1965. They are both state as well as local, so city or county laws. They primarily limited African Americans' rights. When we say Jim Crow laws, we're referring mostly to African American rights, but there were certainly laws that limited other people of color's rights as well. So definitely the biggest one was trying to limit African-American participation in voting, right? With like poll taxes, you have to pay money to vote, literacy tests, grandfather clauses, things like that. It made it illegal to marry outside of your race, and that was illegal for a very long time, up until the 1970s in most states. As well as the mandated segregation of things like schools, public transportation, and restrooms. So the Supreme Court case that really put Jim Crow laws into like federal, oh, I lost that sentence. So the Supreme Court case that really made it okay for US states and counties to have Jim Crow laws was this case, Plessy versus Ferguson, which was argued in 1896, so pretty old Supreme Court case. So this picture here is Homer Plessy. He was a mixed race man, so he was both black and white. He was riding on a train and he was told he had to move to the colored car on the train. He refused and was arrested. And just like Rosa Parks, this was a planned action. It wasn't something he just did. He was actually supported by an organization we'll talk about in a minute called the NAACP to basically make a test case to try and get these Jim Crow laws overturned. Anyway, so he refused and was arrested, and this case went to the Supreme Court, and basically they were arguing that under the 14th Amendment, everyone has equal protection under the law, and that public segregation in this manner is not equal protection because it's treating people of races unequally, right? So the Supreme Court actually ruled against Homer Plessy. They upheld racial segregation and in their famous phrase said segregation was fine as long as it was separate but equal. So in the Supreme Court's mind, it was okay for there to be racial segregation, but it had to be equal. Of course, in practice, it was almost never equal. It was always separate and often not equal. But this was a way kind of like the US got around saying like segregation doesn't follow the 14th Amendment, and they would say, oh, but we have separate but equal, right? So here you go, right? 14th Amendment, every citizen gets equal protection of the laws. So this was their way of the US and the Supreme Court's way of getting around their own amendment, right, that they had passed during Reconstruction. Okay, so remember, it's important to think about the Supreme Court in terms of this. They do not make laws. Congress makes the laws, right? The Supreme Court's job is to interpret the constitutionality of previously made laws. So basically, they were saying Jim Crow laws were constitutional as long as they were separate but equal. So they would follow the 14th Amendment if they were separate but equal, right? So that's the Supreme Court's job. Basically, they can say that something is illegal if it does not follow the Constitution. So in the case we're going to talk about here, right, Brown versus Board does not make public school segregation illegal. It says instead it says the laws that segregate schools are unconstitutional and therefore void. They don't exist. So that's kind of an important distinction. And when you get to civics next year, you'll talk more about this. Okay, so one of the driving forces of the civil rights movement and of both Homer Plessy, Rosa Parks, and the Brown versus Board movement was this organization, the NAACP, which was the National Association for the Advancement of Colored People. And their main goal was to end de jure segregation in America. So they'll come up again and again as we talk about civil rights. Their main lawyer was this guy, Thurgood Marshall. He was the head of the Legal Defense Fund for the NAACP, and he actually became the first African-American Supreme Court justice, which was a huge accomplishment. Okay, so let's talk a little bit about the state of schools in the South under segregation before we start talking about Brown versus Board. So some example statistics for you. In Atlanta, Georgia, spending for Black versus white children, $228 per Black student, versus $750 per white student, right? 36 Black children per classroom versus 22 white children per classroom. And you've all been in big classes and small classes and you know the difference that makes. More examples in Clarendon, Virginia in the 1950s. There were 3 Black schools for 808 Black students versus the 2 white schools for 276 students. And most Black schools, especially in the South, were very poor. They didn't have running water. There were some without electricity. A lot of them were one-room schoolhouses, right? It was not a great time. And there was even segregation in the curriculum, right? White schools tended to shift white students more towards professional jobs so they could take things like biology, typing, and bookkeeping, versus in Black students, the curriculum was aimed towards more domestic servant or manual labor jobs like agriculture, home economics, because that was kind of the job path for Black and white students. Right? White students would become professionals, accountants, doctors, lawyers, secretaries. Black students would become home servants, nannies, field workers, etc. Right? So there was even segregation in what they were learning. So now we get to the Brown family, and that is the Brown family there. Linda Brown is 7 years old, and she registers for school at the Sumner School in Topeka, Kansas. So basically the Brown family, supported again by the NAACP, sued to protest the segregation of schools. Linda Brown wanted to go to the better school, which was the white school, and she was not allowed to. So they basically sued the school board district. And this became probably if not one of the most important Supreme Court decisions of all time. And again, when you get to civics next year, you'll definitely talk about Brown versus Board, because it really kicks off the whole civil rights movement. And it's really the first time that since Reconstruction that an effort has been made to enfranchise people of color in the United States. And the decision also kicks off the civil rights movement. So we're going to go over to the decision. I'll share it with you. I'll also attach it to my website and in Teams, and then we'll read it. And then I would like you to come back and just pause, and you can answer these questions in your notes. Okay? There we go. Oh, trying to figure this out. Okay. Okay. So this is some excerpts from the unanimous decision by Chief Justice Earl Warren. So he says, today, education is perhaps the most important function of state and local governments. Today, it is a principal instrument in awakening the child to cultural values and preparing him for the later professional training, and in helping him to adjust normally to his environment. And these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right in which must be made available to all on equal terms. In this case, there are findings that the Negro and white schools have been equalized, or are being equalized with respect to buildings, curricula, qualifications, and salaries of teachers, and other tangible factors. Our decision, therefore, cannot turn on merely a comparison of these tangible factors in the Negro and white schools involved in each of the cases. We must look instead to the effect of segregation itself on public education. To separate them, referring to children in grade and high schools, from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely to ever be undone. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs are deprived of the equal protection of the laws guaranteed by the 14th Amendment. Full implementation of the constitutional principles may require solution of varied local school problems. The courts will require that the defendants make a prompt and reasonable start towards full compliance with our May 17, 1954 ruling. The burden rests upon the defendants to establish that such time is consistent with good faith compliance of the law. To that end, courts may consider problems related to administration arising from physical condition of the school plant, the school transportation system, personnel, revision of school districts and attendance areas into compact units to achieve a system of determining admission to the public schools on a non-racial basis. The cases are remanded to the district courts to take such proceedings and enter orders and decrees consistent with this opinion as are necessary and proper to admit public schools on a racially non-discriminatory basis with all deliberate speed, the parties to these cases. Okay, so that's a lot. So there's a couple paragraphs I think are really important. Definitely, we conclude that in the field of public education, the doctrine of separate but equal has no place. And also to say that to separate students from others of similar age and qualifications because of their race generates a feeling of inferiority. So to me, those are the two most important pieces of these excerpts. Okay, let's go back to the PowerPoint. Okay, so take a moment and pause here and just answer these questions in your notes. Okay, so let's talk about the significance of the Brown versus Board of Education decision. So one, they say separate but equal is inherently unequal. So they say it doesn't matter if it is equal, it's inherently unequal just by virtue of being separate. Two, this is a beginning of the end of public segregation, right? Even though this is very specifically only applying to public schools, right? This is kind of the death toll for de jure segregation. And three, it kicks off the civil rights movement because all of a sudden, the United States moves towards giving African Americans and people of color more legal rights. And that hadn't happened for essentially a century. Essentially, a century is a fun phrase. Okay, so just some brief Martin Luther King Jr. quotes on segregation. There are at least three basic reasons why segregation is evil. The first is that segregation inevitably makes for inequality. Segregation sears the soul of both the segregated and the segregator. It gives the segregated a false sense of inferiority and the segregator a false sense of superiority. It ends up depersonalizing the segregated. This is why segregation is utterly unequal and utterly unchristian. So Martin Luther King sees the act of segregation as inherently wrong. It doesn't matter if it's equal. It doesn't matter if it's done to try and protect people. It's inherently wrong because it creates a sense of under and over classes. Okay, so the first high school students to try and integrate a white high school were these people who were called the Little Rock Nine. And they, again, like the Brown family, like Homer Plessy, like Rosa Parks, were supported by the NAACP. So you can see these are the 9 teenagers who were attempting to integrate a white high school in Arkansas, and they're with Daisy Bates, the Arkansas NAACP leader. So basically, these 9 Black students volunteered to integrate Central High School in Little Rock, Arkansas, which is a state that has historically been extremely pro-Jim Crow and segregation. So they basically, the federal government, the Supreme Court says, hey, Arkansas, you need to integrate. And these 9 students will be coming to this white school. And the Arkansas governor, whose name is Orville Fatt, basically says no, right? And he calls up the Arkansas National Guard to actually surround Central High School and keep out the 9 Black students, right? So literally he's using the army to stop integration. That's how strongly he felt about this. And as they as the Little Rock Nine tried and entered the school, they were pelted with abuse, things being thrown at them. You can see here a white woman, right, screaming at this Black high schooler. There was a lot of opposition from the white community in Arkansas. So the federal government basically does a couple things. First, a judge passes down what's called an injunction that says, hey, Governor Fatt, you can't use the military in this way. You can't use the National Guard to prevent students from going to school, to prevent teenagers from going to school. Fatt says, all right, I'm not going to use the National Guard, but the Little Rock Nine should stay away if they wanted to stay safe. So he basically threatens these teenagers' lives for trying to attend school. And at this point, the president, who is at this time President Eisenhower, intervenes. Remember, because it's the president's job to enforce the laws. So Eisenhower calls up members of the U.S. Army's 101st Airborne Division, which is one of the most prestigious divisions of the military, to protect the students and to escort them into Central High School. And they are escorted back into the high school for their first full day on September 25th, 1957, under federal troop protection. So you can see here in this picture, these are Army soldiers, professional soldiers with guns escorting teenagers to go to class, right? And they suffer constant harassment, right, for attempting to go to school for months and months. And it's so bad that the federal government assigned them personal guards from soldiers. So they had people like escort them to class and all around school and stay with them, essentially, so they would not get hurt and harassed for trying to go to school. All right, so that is the end of our lecture. Tomorrow, you're going to look at the Emmett Till case, which was another one of the things that really kicked off the civil rights movement. And then next week, we'll look at the gains and losses that people like Martin Luther King and Malcolm X were working for during the civil rights movement. All right, remember you can ask me a question over email or in our team, and I hope you're having a great day.